Welcome to today's webinar, Managing the Safety of Visitors and Employees and Restructuring Your Workforce, COVID-19 and Beyond. This is the second installment of a three-part segment on relevant issues to employers and employees alike in the very turbulent and changing economic and work environment that the COVID-19 pandemic has created. I am Damia Dawes-Monthrope, attorney at law and the third vice president of the Montego Bay Chamber of Commerce and Industry, organizers and coordinators of this webinar. And we have done so in conjunction with Dunncox, a well-known full-service law firm with offices in Kingston and Montego Bay, as well as with the University of the West Indies, WJC, Western Jamaica campus, here in Montego Bay. It would be remiss of me not to thank the organizing committee of the Montego Bay Chamber of Commerce. Our president, Janet Silvera, sits on this committee, as well as second vice president, Carolyn May, myself, directors Mary Chambers Hector, and director Paulette Neal, also a presenter this morning. As a chamber, we really wanted to assist our members in particular with information on relevant and timely matters pertinent to their operations in the current climate and ensuring they are aware of the potential pitfalls or areas of liability that could leave their organizations vulnerable and exposed, opening them up to significant loss or claims, and so providing information and insight into how to maneuver and operate in a socially responsible way and in a responsive way is paramount importance. Now, just a few housekeeping matters in the way that we proceed with today's webinar. We will have the first presenter, and he will present on his topic. And after the presenters present, both presenters present, we would then go into the question and answer segment. So please feel free to pose your questions as they come to mind, and we will have the presenters field them afterwards. And without further ado, let's get into it. Our first presenter today is Mr. Emile Labo, partner and co-head of Dunncox's litigation department. He is the sitting president of the Jamaica Bar Association, practices in employment law and civil litigation, and he's also chairperson of the Jambar Industrial Relations and Labor Law Subcommittee. He's an associate tutor in civil procedure and practice at the Norman Manley Law School. He is presenting the topic, Managing the Safety of Visitors and Employees, COVID-19 and Beyond. Mr. Emile Labo.
Good morning, everyone. Thank you very much, Damien, for that pleasant introduction. One of the things that is noteworthy about the current situation from an employment law perspective is how throughout the world we are all grappling with the same issues. So this is probably one of the occasions where legal issues are fairly centralized. Now, one of the differences in territories between how it's dealt with by various territories depends on the level of legislation and the common law, what they call the case law decisions of the courts that are applicable to the particular jurisdiction. One of the main points of distinction for Jamaica is that we do not have any occupational safety and health legislation. So, for example, places like Canada, and I've been watching some of the webinars from Ware Folds and so on, where it's clear that they have occupational safety and health legislation, and it provides a framework for how they approach issues like this because there is legislative guidance. Now in Jamaica, that legislation is still in draft and they're still contemplating its enactment and what final form it will take. So as of course we can't afford to wait on that. So we have to operate in the state of the law as it exists today. So the first thing we're going to do is understand and identify what is the law in Jamaica. Now, in Jamaica, I'll start off with this image to give you an idea of what I call the perspective that some Jamaicans and employees and even visitors may have to safety guidelines and guidance. So you may be told to wear masks, you may be told to sanitize, you may have some nice warning labels, directions and so on. But you're still tempted to take off that mask because it is hot. You may not like sanitizer, you may not, you may be allergic to it, who can say? And so you may have different degrees of compliance with the guidelines that have been issued. So the question then is, what do you do and what is your framework? Now, my focus today, because we don't have time for what I call a very in-depth discussion, is in the tourism industry specifically. So as we are partnering with the Montego Chamber, we know that is an industry that is a central focus in that part of the island, but is of course important to the nation as a whole, because our sliding dollar will show you, of course, the importance of the tourism industry to Jamaica as a whole. Now, the tourism industry brings together many categories of people. So there is a fairly large segment of short-term contract workers. You have permanent employees. Now, short-term contract workers, as most of you probably already know, are people who are employed for a very specific period of time. Usually a 3-month contract, a 6-month contract, sometimes a 1-year contract, but it has a fixed endpoint at the time that it commences. You also have permanent employees. Now, permanent employees, as we know, doesn't mean that they are there for the entirety of their lives, but they are, in fact, on contracts that have no fixed end date. The third category are independent contractors. So those are the individuals who would provide services to the hotel, whether it is food services, whether it is bus services, whether it is entertainment services to come do a show and leave and so on, who are not employees of the particular institution, but they do interact with and interface with the staff. And of course, most importantly, the entire reason why all the other 3 categories are there are the guests or visitors who are coming onto the premises. So the first thing we're going to look at is what's called the common law. Now, despite its name, the common law really is not necessarily because it is common as versus special law, but it is the law as determined by the courts as versus parliament. So under the common law is determined based on, as I said, decisions. So one of the decisions of the court we're going to look at now, this is a British case, or this judgment of the British court, but it's still relevant to what we're looking at. The liability of an employer to his employees for negligence is not a separate tort on its own. It is an aspect of the general law of negligence. Now, what does that mean? The law of negligence basically says this, is that once it is found that you have what's called a duty of care, and that simply means a duty to ensure the safety of a third party, then you have to take reasonable steps to ensure their safety. So under the law, you would have a duty of care that would be owed. So you are the employer, you are and so as the employer and as the occupier of the premises, you have a duty of care to your employees and to your visitors. So, and that duty is to take reasonable steps to ensure their safety. So the first thing we're going to look at as an employer in respect of employees is what does that duty look like? What would constitute reasonable steps to take care for safety? So the first item would be the provision of safe staff. Now, what does safe staff mean? Safe staff means that you have given directives, guidance, policies where you're saying to your staff, listen, we will not tolerate behavior that endangers other staff members. So if you like to run jokes where you're pushing people into pools, pushing them by the edges of balconies and so on, that's not the type of staff we want. So if it is that you engage in that behavior, we may take steps to either rehabilitate you or we might take steps to separate you from your employment. So the next item would be a safe equipment. Now, safe equipment in the context of the current situation will vary. Now, it is worthy of note, of course, that the presence or existence of COVID-19 does not mean that there are not other dangers. The dangers that existed before still exist. The safe equipment is not just limited to a mask and a bottle of hand sanitizer. But in this instance, safe equipment may vary depending on the level of interface with guests, with other members of staff. So it should be whatever is necessary to, again, ensure that the individual is reasonably safe. Safe place of work is also an indication in terms of the physical structure of work. Now, the physical structure of the workplace, now usually that would take the form of ensuring that the floors are not slippery, ensuring that their surface is smooth so people don't trip, ensuring that there are no exposed nails, broken glass, and so on, and a place where there's a limited likelihood of injury, but you of course can't prevent every slip and fall. For example, in an outdoor space, you can't control the flow of rain. If it rains, and you can't cover every inch of a property. Now, in the COVID-19 context, a safe place of work may well be a place that has sufficient square footage for social distancing. So this is one of the things that you have to look at. What constitutes a safe place of work in the context of the COVID-19 era, as it were. Now, a safe system of work. What's a system? So one of the difficulties that we will see and that I have seen in terms of day-to-day operations is that the systems that are in place sometimes are oral, meaning that they're not written down. So you come to work and someone tells you, you need to do this, you need to do that, you need to do that, but it's not necessarily documented, right? So an essential aspect of a safe system of work is to have a written policy setting out that this is what you need to do. You need to do A, you need to do B, you need to do C. Setting out the steps that have been taken by the employer to ensure the safety, and then also the obligations of the employee. And this is critical because a lot of the steps that need to be taken require participation by the employees. So if one employee is inclined to keep social distance and the other is not, then unless one is going to run away from the other one, you can see how a difficulty would arise. Similarly, in the context of wearing masks, one person wearing masks is significantly less effective than both individuals wearing masks. Similarly with sanitization and cleaning, but also safe system and the safe place may also involve the sanitization procedures and so on that are in place. And ensuring that the employee signs agreeing to take these steps, because that now ties into what the Homer Simpson situation, where even though the systems are there, you might choose not to follow it. But in order for an employer to take any steps rather to enforce such a system, the employee needs to have signed to and agreed to comply with these steps. Right. Now, the question also is, what steps do I have to take? If I'm a smaller enterprise as versus a larger enterprise, do I have to take the same steps that the larger enterprise does? No. The duty, as we see here, is to see that a reasonably safe place of work is provided by the employer and maintained. So the place of employment should be as safe as the exercise of reasonable skill permits. Right? And so what that means is that you don't have to spend your entire budget and put yourself in a loss position in order to put in place elaborate systems where you have cameras that can automatically read temperatures and put in place reports and so on. Some places of work may be able to reasonably put that in place, while others may not. So the whole concept of reasonableness is at least partially determined by the size of the facility and the income level of the facility. So even though there are guidelines, they can well be adapted or adopted in the way that is most reasonable, bearing in mind the, as I said, the nature and size of the premises. Now, there's also the very live question as to whether COVID-19 has made the workplace unsafe. All right. Now, owing to what could be described as an exceptional and transient danger. Now, clearly, the answer to that would be no. Insofar as if the answer were yes, that would suggest that none of us should be at work. I shouldn't be here. You shouldn't be wherever you are unless it is that you're working from home, right? But certainly as Jamaica has reopened and gradually reopened its borders and workplaces, we're all still at work. Now, the reality is, of course, that any one of us may contract the virus that would cause the coronavirus that would cause COVID-19. Now, but you could contract that at the supermarket, you could contract that walking down the street, you could contract that at the workplace, you can contract that anywhere. So the question is, what steps do you need to take to show that you have made reasonable efforts to ensure that an employee does not contract COVID-19 or the coronavirus? So the fact that someone contracts the coronavirus at work, well, assuming that one can prove that it was contracted at work, does not necessarily mean that an employer is liable if they can show that they took reasonable steps to ensure safety. That is, of course, my view, because there is not yet any decided court decisions on the coronavirus and steps taken by an employer to prevent the spread. Now, some of the issues which arise as well is if someone at the workplace is infected with the virus, in whom should that knowledge reside? Can the knowledge of an employee at a non-supervisory level that one of their co-workers has tested positive for COVID-19 be imputed to the employer? What does that mean? So let's look at a situation where you can have line staff. A line staff member may have a friend, family member, or someone who lives with them who, to their knowledge, has tested positive for the coronavirus. That person tells no one that this person with whom they associate regularly has tested positive for the coronavirus. That person continues to come to work because they don't want to put their income at risk. Now, it then turns out that that person becomes what's called a super spreader. So they walk all over the place of work, and the significant portion of the staff that works with them contracts COVID-19. Now, could the employer be held liable in that situation, assuming, of course, that they took reasonable steps to avoid the spread? Now, to me, the answer to that would be no, because if it is that only that line staff only told another line staff member, because this is the thing with a company. The knowledge of a company resides in its supervisors, its managers, people who make decisions, who can say, okay, yes to this, yes to that. So if it is that a supervisor or manager was aware that a staff member had contracted or was at high risk for COVID-19 and still had that staff member walking around and so on, then the company could be liable to other employees who contracted it. However, once it is that the person who has knowledge of it, is not someone who could make decisions in the workplace, then it's going to be much more difficult for liability of the company to be established. Right? So that is another aspect of the type of policy you need to have in place. You need to have a reporting obligation on the part of staff to say, hey, I may be at a heightened risk for contraction of COVID-19, or I suspect that I may have already contracted COVID-19. And so I have an obligation to report this fact, this possibility, to somebody in management who can make a decision about it. Now, again, when we look a little deeper into the whole context of, say, system of work, right? The general concept and the general definition is this: where the mode of operation is complicated or highly dangerous or prolonged, or involves a number of men performing different functions, or where it is of a complicated or unusual character, a system should be prescribed, right? So clearly, as for all the reasons I've just said, COVID-19 creates a complicated work environment. And so if it is that the matter were to proceed to court, it is quite likely that a court would find that a failure to have a system, whether or not that is a good, bad, or medium level system in terms of complexity and depth rather, just the failure to have a system may well constitute a form of negligence on the part of an employer. Now, there's also, when it is that a claim is brought in the context of negligence, this concept of contributory negligence. So, over the years, it has been distilled in many cases that an accident in the workplace may be caused by the fault of the defendant. The defendant is usually the employer, the company, etc., and by the claimant's failure to take reasonable care for his own safety. So one of the defenses that an employer could have if a claim is brought by a specific employee is that here are the things that I gave you, here are the things that I put in place, and you as the employee did not use or did not properly use what was provided to you. So I removed 3 chairs and I kept you 6 feet apart. You decided that you wanted to take the chance and you felt that your coworker looked healthy and you move the chair closer together to that co-worker. Then that co-worker perhaps may have contracted coronavirus and then you got it. But the fact that the employer had in place a system, you decided to go around that system, not follow the guidelines. You're supposed to wear your mask at all times. You choose not to wear your mask at all times. You now have voluntarily placed yourself in a situation of higher risk than you otherwise would have. And so in those circumstances, a court may look at your conduct, look at your actions and say, you are at least perhaps 50% or maybe 75, 80% liable or responsible for the fact that you contracted COVID-19 or any other communicable illness. Now, the question of, does the presence of COVID-19 in the workplace require a new system of work? I would say no, it's not a new system. It's not that your existing infrastructure, everywhere that every environment, a workplace environment should have some degree of policies regarding occupational safety and health, meaning that it should be a disciplinary offense, for example, to engage in what they call horseplay, meaning that conduct that is not work-related and that may result in injury, all right, that may be all in the spirit of fun, but could result in potential injury. And so you should really just be adding to the existing infrastructure that is in place. That being said, of course, I think it may well be appropriate to have what I call a COVID-19 policy for your workplace. As we see, though, that there are new and more interesting diseases and possible future pandemics that seem to be cropping up every day. So it may well be a communicable disease policy rather than a COVID-19 policy per se. Then we also look at the proper supervision in terms of the organization, because it's one thing to have in place the policy, and it's quite another to ensure implementation. Is anyone observing, or did someone just write something down on a piece of paper, hand it to an employee to sign, and say, go forth? All right? Is there any kind of auditing being done to ensure that masks are being worn and that type of thing? What steps are you taking to ensure that these policies, these nice, shiny bits of policies and amendments to employment contracts that you have put in place are being complied with? So in terms of this question here is, again, something that I had just discussed. Now, if it is that the difficulty, and again, I'm certainly not a doctor or medical professional, but an employee or a litigant will always have a difficulty in proving that here, this location right here is where I contracted COVID-19 as versus somewhere else. Unless it is that we get to the point where nowhere else in the country is proven to have it, and it could only have been contracted here, right? And then also we look at the different types of practices and so on. So it may well be that in certain circumstances, the employee could be found to be fully liable. So if the matter were to proceed to court, we would look at, the first question would be whether what they call an balance of probabilities. Is it more likely than not? So when a lawsuit or a claim is filed in court, this is what the court would look at. This is the standard by which the court would assess it. So is it more likely than not that the claimant became infected at a location under your control? The next question is whether you took reasonable steps based on the knowledge available to you, the resources available, to prevent or limit the likelihood of visitors and or employees becoming infected. Did you apply any government or industry guidelines for return to work? If it is found that you failed in that duty, what loss did the claimant suffer as a result of your failure? And this could range, of course, from nothing to compensation on a wrongful death basis. On that last point, when I say compensation could be nothing, it means that the mere contraction of COVID-19, unless it results in loss of employment and so on, and let's say, for example, you're asymptomatic, the mere contraction of it without any symptoms are not likely to result in an award of damages, right? Because damages usually, in assessing damages, the court would usually look at, have you been in pain? Have you been injured? Have you been unable to carry out your day-to-day activities? Are you limited in your life functions? Or have you suffered in your life functions in a way that you should be compensated? Now, we of course know that there are individuals with what they call comorbidities and so on, which may be at a higher risk. And of course, they may well die in an extreme circumstance. And in that case, their estate, their families, and so on could potentially institute a claim. Now, as both an occupier, now I've been speaking mostly about employees, but the similar principles applies to as an occupier in respect of visitors. So duty of care and negligence and so on, those things are equally applicable, although perhaps you may go about it in a different way with occupiers. So can you exempt yourself from liability by requiring visitors to sign a waiver, inserting exemption clauses in employee contracts? As we know, as with any waiver exemption clause, liability for damages or injury resulting from gross negligence on the part of the occupier employer cannot be excluded. However, only time will tell the extent to which any such clauses will be upheld in the context of COVID-19. Now, that again briefly says that it's not that it is worth less for you to have these documents signed, but it still doesn't remove you from your obligation to put in place steps to reasonably prevent a likelihood of an individual becoming infected. So it's not a cure-all. So it helps, it's part of what I call the arsenal, but it does not completely exclude you from liability. So those are, just as a main overview, some of the things that an employer and an occupier needs to look at in the context of reopening for COVID-19. Thank you very much.
Thank you so much, Emil, for that very edifying and informative presentation. And now we will have our second presenter for today, presenting on the topic, Restructuring Your Workforce, COVID-19 and Beyond. She is Miss Paulette Neal. She is an associate at Dunncox. She is a member of the Litigation, Commercial, and Conveyancing Department at Dunncox. She is a member of the Jamaica Bar Association, treasurer of the Cornwall Bar Association, and a director at the Montego Bay Chamber of Commerce and Industry. Now let's hear from Miss Paulette Neal.
Thank you, Danielle. Good morning, everyone. So for this part of the presentation, we'll be focused on restructuring your workforce, COVID-19 and beyond. Now, March 2020 has marked a significant period in Jamaica's history. In that month, Jamaica confirmed its first case of COVID-19. Shortly thereafter, our country's air and seaports were closed to incoming passenger traffic. Now, as a consequence of that, many businesses, particularly in the hotel and tourism industry, were forced to close. And unfortunately, due to the closure of these businesses, thousands of workers were laid off in what were deemed uncertain times. Now, Section 5A1 of the Employment Termination and Redundancy Payments Act provides that an employee who has been laid off for a period in excess of 120 days may, by notice in writing to the employer, elect to be regarded as dismissed by reason of redundancy from such date not being less than 14 days or more than 60 days after the date of the notice. Now, what this means is that if an employee was laid off, for example, on March 15th, and is still laid off, come July 14th, that employee may give notice to their employer in writing and elect to be dismissed by reason of redundancy. Now, a redundancy situation can also arise at the option of the employer. So Section 52A and B of the Employment Termination and Redundancy Payments Act provides that for the purposes of this part, an employee who is dismissed shall be taken to be dismissed by reason of redundancy if the dismissal is attributable wholly or partly to A, the fact that his employer has ceased or intends to cease to carry on business for the purpose of which the employee was employed by him, or has ceased or intends to cease to carry on that business in the place where the employee was so employed, or B, the fact that the requirements of that business for the employees to carry out work of a particular kind, or for employees to carry out work of a particular kind in a place where he was so employed have ceased or diminished or are expected to cease or diminish. Now, let us look at a practical example of how redundancy can arise at the option of the employer in pursuant to Section 52A of the Employment Termination and Redundancy Payments Act. So on May 15, 2020, an article was published in the Jamaica Observer titled NCB Closes More Branches, Banks on Cashless Model. Now, in this article, it was announced that NCB will be closing its Half Moon, Anotta Bay, and Chapelton branch. Now, the article also indicated that while the bank started this program in 2019 ahead of the local onset of COVID-19 virus, the CEO, Septimus Blake, said that the changes are now even more timely given the emergence of new norms like physical distancing and the demand for more digital channels. So we can see by this example that from the closure of the 3 branches of NCB, if an employee that worked at one of these branches is dismissed, that employee could be deemed to be dismissed by reason of redundancy for the mere fact that the branch is closing. Now let's fast forward a bit to July 3, 2020. Another article was published, this time by Luke, and it's headed, NCB cuts over 100 jobs in redundancy exercise. So we can see that NCB had announced the closure of 3 branches, and a result of the closure of the branches, NCB had to cut over 100 jobs in a redundancy exercise. Now, at this point, we know that as a redundancy exercise can arise if an employee elects to be dismissed by reason of redundancy. Also, a redundancy exercise can arise at the option of the employer. Now, the focal question at this point is, can businesses restructure their workforce to avoid redundancies? And the simple answer to that is yes. In fact, the Labor Relations Code recognizes the need for workers to be secure in their employment. And the code also says that management should, as far as is consistent with operational efficiency, in consultation with the workers, try as best or take all steps to avoid redundancies. Management should also, in consultation with their workers, evolve a contingency planned with respect to redundancy, so that in the event of a redundancy situation, workers are not left to face undue hardship. Also, the Labor Relations Code provides that management or the employer should actively assist workers in securing alternative employment. Now, let us look at some of the alternatives to redundancy. And the first one that we will look at is redeployment. Now, what is redeployment? This is the movement of an employee into a different role or into a different position or to a different department within the employer's business or to that of an associated employer. Now, whilst using the NCB as an example, while the employer may no longer have the need for business to operate at a particular branch due to the closure, the employer can actively try to see if or conduct an assessment to see if there is a need in another branch, and to see if any of the employees who were employed at the branches to be closed can be fitted at any of the other branches. Now, there's a recent IDT case, Leon Marrett against the Bank of Jamaica, where it was opined that consultation is not just communication of what is about to happen. It included providing the person with a bona fide opportunity to influence the decision maker. So what this means is that the employer, in trying to seek alternative employment, they should not go to the employee to say, this is what we're going to do. Actively engage the employee, seek their opinion in trying to assess where to redeploy these employees. Now, redeployment, a change in the terms of the employment contract may arise. And due to that, the employer will need the consent of the employee, because any unilateral change in a person's or worker's employment contract will be considered a breach. Unless it is that the employment contract contained a mobilization clause, which would allow the employer to unilaterally relocate the employee at their sole discretion. Now, there's what we call unreasonable refusal of alternative employment. So if an employee was offered, or an affected employee rather, was offered alternative employment of no less beneficial than his previous employment, and that employee refuses the offer, then that employee can lose his right to redundancy payment. And Section 6.3 of the Employment Termination and Redundancy Payments Act outlines this. Now, another alternative to redundancy is engaging employees on a reduced working time or reduced working days and reduced salary basis. Now, many businesses, and this is particularly the hotel and tourism industry, so destination management companies, tour operators, they are now seeking to reopen, and hotels, obviously. However, they will not require the full complement of their staff. So what these employers may do is to engage the employees, be honest with them about the status of the business, and to see if you can get them to agree to a reduction in working days or working time. And the employee would be asked to agree to a commensurate reduction in salary. Now, for this method, you have to get the employee's express written consent. Again, any unilateral change in the contract by the employer will amount to a breach of the contract, and it exposes the employer to liability to court action to damages. So the effect of this is that the employer will be able to save company output and to preserve employment and thereby avoiding redundancy. Another option for the employer is voluntary early retirement. Now, and I will stress voluntary. So businesses may consider seeking volunteers for early retirement, but this is only a viable alternative to redundancy if the business has its own regulated pension scheme, and the pension scheme must allow for early retirement. Now, businesses should carefully consider whether it may need to make a payment under the pension fund and the cost effectiveness of doing so. I'll quote a section of the book Employee Relations when discussing early retirement at page 336. It stated that, so for any individual to seriously consider an option, early retirement must carry some form of financial inducement. In effect, the potential retiree is credited with more years of pensionable service than he or she would usually work. The question of how many extra years to credit and how near to normal retirement age of a particular employment is the ability of the employer to make the necessary payments into the fund. So what this means is that the employer should conduct an assessment, because you would not want to have a situation where you're making a contribution into the fund which will be more than the redundancy payments. So this should be carefully considered by the employer. However, if an employee is dismissed, well, not dismissed rather, but the contract is terminated by reason of the employee's retirement in circumstances where the employee is entitled to pension or superannuation or other retiring benefits, then the employee shall not be entitled to redundancy payments. So this is one option to be considered by employers. Another option is employers could consider withdrawing job offers or postponing new starts. So an employer can withdraw an offer at any point before the offer is accepted without having to give notice or payment in lieu of notice. Businesses can also opt to postpone a start date. However, if this offer has already been accepted by the employee, then the consent of that individual will be required to defer the start dates. Now, what if after considering all those options, redundancy may very well be the only option? So what should the employer do in this instance? Warn the employee about the possibility of redundancy. Remember, you always should consult with the employee, and it is not just telling them what will happen, but engage them. Engage them or their representative, seek to get their opinion, actively try to find alternative employment, and adopt a fair and objective basis for this selection. The employer should also ensure that the criteria stipulated in the Employment Termination and Redundancy Payments Act are used and fairly applied. Now, employers should also note that if it is that they are embarking on a redundancy exercise, they should notify the Minister of Labor of their intention to undertake a redundancy exercise. And their failure to do so is considered a criminal offense, which is punishable by a fine or imprisonment, and the maximum fine is 250,000 Jamaican dollars. The employer, and lastly, the employer should also determine whether the employee is entitled to redundancy payments. Now, if that employee was continuously employed for a period in excess of 104 weeks, then that employee would be entitled to redundancy payments. So thank you, ladies and gentlemen. Now over to you, Damien.
Thank you so much, Paulette. Very practical and timely, relevant information. So we have heard now about the duty of the employer to the employee, the duty to provide a safe place of work, safe equipment, and a safe system of work. This is a common law duty and obligation for all employers to their employees. We have learned about the duty of care by the employer to the employee in the context of the COVID-19 pandemic and how employers can protect themselves. To what extent employees also need to take care to ensure there isn't contributory negligence and to ensure that they fulfill the legal requirement to mitigate risks on their part as well. Then we also heard about possible ways to restructure the workforce. After all, this pandemic has tested the elasticity of demand for operations for employers. It has tested the financial viability of their operations. Does this absolve them in this pandemic era? Because this is an act of God, a force majeure, something no one could foresee. And we see that this is not the case. Dunncox has presented that the Jamaican laws have rescinded. They're still relevant even in this pandemic era, in this new normal. That the Employment Termination and Redundancy Act does not end just because of the pandemic. Employers aren't just given an out. We have seen that there are options for employers. There is the redundancy option and what processes and procedures must be followed to ensure that employers are not liable. There is the restructuring option, the redeployment, the reduction in hours, and consequent reduction in salaries, as well as the early retirement option. And so at this point, we would move to the question and answer segment of our webinar. And before we do so, I want to remind everyone viewing that after the webinar, please ensure you stay on and complete the survey that you'll receive in your emails. And you will also receive the presentation that have been presented here today. So that's the importance of registering. Ensure you register for future webinars as well. Let's go into the question and answer segment. I'm going to remind you, please put in your questions so that we may have them fielded by our presenters. As moderator, I hope I may have the privilege of the first question to our presenters this morning. I listened carefully about the employers setting up the policy to ensure that employees advise in the event that they have contracted COVID-19. But what about the right to privacy in this COVID-19 situation? Does that go out the door? What are the obligations to employees and the responses to employers where employees say, that's my business. Why do I have to tell you that?
Thanks very much. That's a very good question. What I would say is that, as we have seen with the NIDS case and with other cases, it is a question of, is it reasonably required in a modern democratic environment? So the right to privacy, like any other right, is not an absolute right. So it's a greater good type of analysis to say, yes, you do have a right to privacy, but in the context of, is your right greater than the right of your coworkers, friends and colleagues to not be exposed to a heightened risk? So certainly my view would be that if it is that such a requirement was challenged, then it is likely to be upheld in the circumstances of the current situation. Now, does that extend to a general obligation to disclose all your medical conditions? No. Meaning that, so if you have a medical condition that does not affect your job performance and it's not communicable, then certainly you would still maintain that right to privacy. But in respect of something that is communicable, that can readily, easily be communicated, then no, I don't think your right to privacy would override your obligation.
Okay, thank you so much. We have a question from Doreen Samuels. In the event an employer is fined for not applying the rules governing a redundancy exercise and the fine is not paid, who will be sent to prison? Managing Director? We can't hear you, Emil. I'm so sorry. I think you're muted.
Sorry about that. You're not fined for not paying redundancy. It's not a criminal offense. It results in a civil liability. So if it is that the redundancy is acknowledged, it's set out and documented and is just not paid, it's recoverable as a civil debt in court. So you can be sued, the company can be sued. If it is that there is in place a company, then the managing director would be separate from the company and would not have individual liability. But if it is that you're simply trading as under a business name and so on, then you are not a separate legal entity, and therefore you would be directly liable and a judgment could be entered against you as an individual.
Okay, thank you so much for clarifying that for Ms. Samuels. And Blondell Wilson Henry has asked, please clarify, must we advise Ministry of Labor before the redundancy or that it has, or after it has taken place?
You should advise the ministry as soon as it has been decided that there will be a redundancy exercise.
Great. Thank you so much. Another question I had, I think, to assist us in furthering the discussion, and that may be something others are considering. Let's say we have a scenario where it's just prior to COVID-19. For Jamaica, that would be, I would say, early March, right? And you have an employee that has a performance issue or a breach of company code of conduct issue, and you were just going to start the disciplinary hearing, but then COVID-19 came in and you didn't proceed. And as an employer, you see this as a perfect time to actually do your restructuring now or your redundancy. Just get rid of this employee. And you may either do the redundancy or you may restructure and change the hours, which changes the salary, right? And this really affects the employee. And in fact, you may be asking them to work from home and do even different things than their job description had initially indicated. Totally significant from what was indicated in the job description. Could an employee say, you're taking this pandemic thing too far? You're actually constructively dismissing me. You really want me to go, so you're putting all of this hardship in my way. How does an employer guard against?
You see, Damien, that's what I would call a multi-layered question, you know.
Right.
The witness would normally, if we were in court, we'd say you'd break it up into about four subsections.
Yes,
But
yes, break it up for us.
let me tackle it from the top. Let me tackle
Yes.
it from the top. So if it is that you had or had commenced a disciplinary proceeding prior to, or let's say you're at the investigation stage, or they call the charging letter setting out the alleged offenses prior to COVID-19, there's nothing preventing you from resuming it. Some instances they have resumed it after back to work. In some instances they have done it via video link. So, and you can physically do it in a socially distant space if it is large enough. So there would have been nothing preventing you from completing that process. If it is, for example, that you decided to take the redundancy route, the redundancy route would require you to be able to justify the redundancy. Because if it is that you have a redundancy exercise, there are two main ways that redundancy is challenged. One, that is not a genuine redundancy. That is something that you make up, cook up, or, you know, you have created it, but it's not a legitimate redundancy. Secondly, it's procedural. So even if the redundancy is substantially justified due to downturn in business, etc., you have not followed the right process. In circumstances where you flow from a disciplinary hearing into a redundancy exercise, there's almost a presumption that redundancy is not genuine. Now, of course, COVID-19 has created a very particular situation that justifies redundancy almost throughout the entire space. But it would be looked at on a case-by-case basis, whether in respect of that particular position, the company had a lessened need for someone to operate in that position. Now, in terms of changing pay structures, remote work, etc., that has to do with the agreement of the employee. That is not something which can be unilaterally imposed. And I think Paulette's presentation touched on this. So when you talk about changing responsibilities, when you're talking about changing the location of work, when you talk about changing pay structure, that has to be with the agreement of the employee, unless you do what was an interesting mechanism that, you know, one or two places may have done, where you did a layoff first and then you offered new terms of employment, which were then agreed subsequently as being what I call layoff employment. That's a different context. Constructive dismissal, which I think is the final aspect now
Yes,
of the multi-layered question, would arise. It's very difficult to prove constructive dismissal. You actually would need to go to court to seek a declaration that you have in fact been constructively dismissed, because there are jurisdictional issues with that in terms of taking that to the Ministry of Labor and perhaps the IDT, which is a more popular route for employees to take. Because if it is that you leave a job and then say you're constructively dismissed, on the face of it, that's either job abandonment or resignation, right? So you now have to disprove. The onus or burden would now be on the employee to say, well, even though it looks like a resignation, even though it looks like I walked off, I was really constructively dismissed, which is a legal determination, a mixed factor law is what they call it. Mm-hmm. And that now is going to be, I would never recommend an employee take that course, because it's difficult for them to establish it. So it is better for them to work within the system and then, you know, take it from there. I hope that has answered all aspects of your questions, Amy.
It actually has. And I wanted to give you that multifaceted question, because life doesn't normally come in neat little packages. You know, there are so many different aspects to it. And we have another question coming in. We have many questions. This one is from Anne-Marie Madden. Can we have employees sign a waiver? You had touched on that in your presentation, Emil, but you may answer, and if so, does it fully absolve them?
Right. So the simple answer is yes, you can. And then the answer to the second part is no. So the waiver is really to create a structure to say, listen, here are the steps I've taken. You've agreed that I've taken these steps. You have agreed that they're reasonable. So it helps to provide you a defense in the event that the person then makes a complaint. But just like any waiver and an exemption clause, say for example, I give you a common example, those parking spaces. We accept no liability for your car being broken into and so on and that type of thing, which when you see it posted on a sign, you haven't signed anything, but they said by driving in there, you have accepted that risk. That doesn't mean that the person who operates the parking facility can just, leave it open to known thieves, make no attempt to secure it, and take no reasonable steps again to ensure the safety of your vehicle and its contents. So waivers and exemptions are what they call strictly construed, meaning that when you go to court, if it can be interpreted narrowly, they'll interpret it as narrowly as possible, and it still doesn't completely remove you. So it's more like it's an assistance, but it's not a complete, it doesn't completely free you from liability.
Right. And just to add to what Emile said, as the owner of a premises, you still have a duty of care to visitors, or if you're an employer, you still have a duty of care to your employees to provide a safe environment.
Thank you. We have a question from Danny Boo 86. Is a disclaimer posted at a business place considered in the same way as a signed waiver form? That is, an employer, company cannot waive damages, injury, death if related to COVID. It's kind of related to that whole waiver. So is the disclaimer the same as what Danny Boo 86 is saying?
The one is what I'd call an implied contract, and one is an express contract. So when someone actually signs a document, it's an express agreement between the parties. That is usually more appropriate if it's an employee who you have a continuing day-to-day type of relationship. If you are in a hotel space and you have a visitor who's going to be there for an extended period. The signage concept is more consistent for people who are in and out of a place. You post a sign at the door, wear your mask, we will not admit you if you don't wear the mask. So that now is, again, you're setting parameters for people entering your premises, but it's a very basic parameter. You don't normally have a sign with two different plaques, if you understand what I'm saying. So you have different mechanisms for different purposes.
Thank you so much. Another question. What restructuring options are available to employers with employees on fixed term contracts? That's from Elaine Doogie. What restructuring options are available to employers with employees on a fixed term contract?
Okay, so it all depends. It depends on when the fixed term contract would come to an end. So, for example, for some employees, their fixed term contract may come to an end if they were laid off during the layoff period, and that would end the employee-employer relationship. Also, in terms of the employer could also seek agreement with the employee for a reduced salary or reduced working hours. But what is important is the consent of the employee, because the employer can't unilaterally make the change. So once the employee agrees, the same principle would apply whether it's a fixed term contract or not.
Okay, thank you so much. A question from Gary Watson. Reasonable step to protect the employee is a subjective phrase. Who determines how objectively the precaution taken was?
All right. So usually this type of analysis takes place in the context of a claim. So somebody is injured, somebody suffers loss, and they go to court, right? So the simple thing is that it's a judge is the one who tends to look at what is reasonable in the circumstances. Now, what is reasonable in the circumstances can vary widely depending on the work environment and the workspace. A factory environment, an office environment, a hotel environment, or if you drive a taxi, it can be different. What is reasonable, I agree, is very subjective, but as necessarily so, because the circumstances can differ so much from place to place and environment to environment. It may also differ from individual to individual, because it may be reasonable to take certain steps for someone who is of advanced age, who is in a workspace, as versus someone who is younger and perhaps less vulnerable. So it all depends on the particular circumstances.
Thank you so much. Let me ask you a question. Could employers receive a claim for hazard pay, especially in Montego Bay, where we have several persons working in the tourist industry? They're almost like first responders. Because guests come in, they've been tested, they haven't gotten their results, and yet they head to the hotels. Could they possibly ask for a hazard?
All right. Well, let's put it this way. There's no statutory hazard pay category in terms of higher risk. So if so, the ones who clean the windows on the 50th floor would perhaps be the highest paid individuals in Jamaica. That is something you'd have to negotiate with your employer to say that I think I'm at a higher risk in these circumstances. So based on that higher risk, I should receive a greater level of compensation. But that would have to be a negotiated position, and it is not something that by law you would be entitled to.
Okay, thank you so much. We have a question from Andy Daswani. We are currently making payroll number 16 to all our team members. However, in opening, we do have some members with underlying health issues. Is there a form or questionnaire to present to these employees?
Well, the simple answer to that is no, one would have to be formulated. So certainly one of the things I've seen since COVID-19, I've been generating and creating a wide range of documents which never existed before. And that a lot of this new space, you're not necessarily going to have templates for it. And that's why legal advice and so on. And you can go to the lawyer of your choice, your preferred counsel. It would be best to have such a document formulated by somebody who has the experience and is able to formulate it in such a way that it achieves the objective that you want to achieve. Because frequently, it's like people who take a will off the internet. A will form, or a Times Square will, a Times Store rather, will, as they call it, can be fit for purpose for some people, but not for everything. And that's where expertise comes in, where sometimes you take forms, you take templates, and you apply them in situations where they're not necessarily applicable or only partially applicable. So I would say get some good advice and get something formulated that will meet your needs.
Thank you so much for answering that. We have a question from Dr. G. Anthony Ferguson. After the redundancy date and the redundancy is agreed, how much time does the employer to pay the employee the redundancy payment?
Okay, so there is actually no provision which stipulates the time in which the employer has to pay the redundancy payment. If it is that the employer does not make the payment within a reasonable time, then the employee can commence action, court action that is against the employer. But there is no statutory time.
Okay, thank you. Joel Bryan, how does a building contractor approach supervision when he or she has multiple locations with 5 or less employees and the cost to employ individual supervisors cannot be borne by each client?
That's an interesting question. The problem you're going to have is that I doubt a court will say no supervision is the appropriate level of supervision. So it may be, I don't know how feasible it would be to put in place some kind of camera reporting system, or actually what you could do is the term surprise visits, surprise audits. So you pop by unannounced, unexpectedly, and you come and see what they're doing. So every so often you kind of turn up periodically, so they know that you may turn up, and if it is that you see that they're not compliant, then they are sanctioned. Then they're more likely to be compliant. So that perhaps might be a mechanism that you might consider to have spot audits as a way to arrive at a middle ground if it is that it's not feasible to afford a supervisor for each site.
Thank you. Janique Williams is asking, will an employee be viewed to abandon his or her position where they are uncomfortable to return to work in the COVID era because of predisposed health conditions? What can the employer do? What can the employee
do? This is an interesting question because it's not really provided for by the law, but certainly mere discomfort is not sufficient. The fact is that your personal view as to your state of health and risk is not the sole determinant. So you would actually need to have a medical report that says that by virtue of this individual and the condition that they have, then they are at a higher risk for contracting COVID-19, and therefore the recommendation is that they perhaps be given provision to work remotely if that is available, or perhaps they may be given a separate cubicle where they have on their mask and they have some face shielding. So this is why I said earlier that the reasonable steps may vary also based on the individual. So that individual, it cannot be, for example, that your employer is obliged to continue to pay you while you are not working, because that now is the fundamental principle of employment, that you are obliged to work and therefore I'm obliged to pay you. It can be, well, I think I'm at risk, so keep paying me while I sit down and do nothing, right? So if that's your starting point, you then have to say, is there a middle ground so that you can do some work and I can continue to pay you? So you explore the various options. And if not, it may well be that some species of medical redundancy may be applicable, because if it is by virtue of that type of work, that type of space, your condition is such that you're no longer appropriate for that job, then it may be that some form of medical redundancy is applicable. Because just like any other injury, because let's say, for example, heaven forbid you have a car accident, you injure your back, you can't sit anymore, but your job requires you to sit and be, doing data entry or whatever it is, then you are no longer in a physical condition that makes you appropriate for that position. So that may be where you end up after you've explored other options.
Thank you so much. From Andy Daswani again, being in tourism, is there any insurance now available to protect our team from catching COVID-19 from a tourist that may not be proven using contact tracing?
Mm-hmm.
Is there any insurance? It's not quite a legal, but I guess, do you know of any insurance policies or maybe anything that an employer can do, any options available to protect their team from catching COVID-19 from a tourist that they may not be proven to be having COVID-19 due to contact tracing?
All right. Well, let me interpret that as a health insurance question, because they're different species of insurance. Let's hope it's not that life insurance is what kicks in.
Let's hope not.
But there's also what has been explored is business interruption insurance. So let's say, for example, you're exposed to, let's say you're a driver, you're exposed to a tourist who has COVID-19, and so you will then become diagnosed with COVID-19, and you clearly can't drive for anybody else after that. Well, until you have been quarantined and you have recovered and so on. So one thing that has been looked at is business interruption insurance. Now, just by virtue of the media, I can say that our local insurers don't seem to offer that package because of perhaps the risk level and being able to price it and that type of thing. So currently there is not business interruption insurance, as I understand it, to cover that. In terms of health insurance, if it is you become sick and ill, so let's say you have symptoms, because you have those who are asymptomatic and
Right.
those who have symptoms. If you have symptoms requiring you to be on sick leave still exists. So sick leave still exists, and health insurance that takes care of illnesses and with the medication, that would still be applicable in a contraction of COVID situation. So there's some things that can still be done within the existing framework, and some things which simply regrettably do not exist.
Okay, thank you so much for answering. Veronica Cousins has asked, should an employer have employees with underlying illnesses on the job doing physical or manual labor during COVID-19?
Okay. All right. Again, it depends on the nature of the job. It depends on the nature of the underlying condition.
Mm-hmm.
So let's use, again, now to an extent, this is a degree of medicine or medical advice, and that type of thing might come in. So you, as I said, lawyers shouldn't give medical advice, and neither should a business operator make decisions that they are based on medical knowledge, which they do not have. So you could consult a doctor, ask the employee to provide you with a medical report that certifies what their condition is. Because, we might say, oh boy, I have sugar, I have this, I have that. And, that to an extent, sometimes there's some degree of self-diagnosis that is involved. So you'd have the medical report, you look at the workspace, and then you look at what reasonable steps can be taken so that that person can still work. Because again, we get back to this concept that it can't be reasonable for someone to keep paying you indefinitely for you to not work. So you have to try to find a way to make it work. If it can't work, then you'll have to end the employment relationship by various mechanisms.
Okay, thank you so much, Emil. Another question is from Jose Vicente Navarro. Can you provide clarity about the difference between a layoff and a redundancy?
Yeah. Go ahead.
Okay, so a layoff would be like a pause, a temporary pause in the person's employment. So the employment contract still exists in a layoff scenario, but there is a pause. In the context of redundancy, the employee would be dismissed, and therefore the employee-employer relationship will no longer continue.
Okay, thank you so much. Did you want to add something, Emil?
Yeah, no, I just said the basic context, as Pauletta said, is one is a suspension, one is a severance. So once the employee elects or you elect to the redundancy, that ends the employment relationship. But the purpose of layoff is to give business owners and employers an opportunity to reduce their payments, their pay bill, and so on for a specified period to potentially resume the business. It is only if the business doesn't seem to be able to resume in a reasonable time frame that you then now get into a redundancy scenario usually.
Okay, thank you. Another question from Mr. Dazwani. What happens if a team member does not follow the mask wearing, hand washing on the job duty? Can they be laid off without redundancy pay for putting other team members and customers at risk?
All right, if an employee fails to follow the requirements and protocol, that is potentially a disciplinary offense. So an employee can be suspended while you investigate and put together the file. As we know, in Jamaica, under the Labor Relations Code, you have to have a disciplinary hearing, and there's a process that can be followed before termination. So if it is that you observe someone who is not following the safety protocols, they can be suspended pending an investigation. You then set up the hearing, and they can potentially be terminated for breaching the safety protocols. But it is essential that you follow procedure.
That's right.
And just to add to what Emile said, the employer would still also have a duty to supervise to ensure that the employee is wearing the proper equipment that are provided to them.
Okay, thank you so much. I believe we are very close to the time. We don't have any further questions, but many questions were fielded. And I believe this has been a very informative presentation. We have given very practical approaches to employers, very useful, and I'm sure they all appreciate it. And as such, we thank Dunncox, we thank Mr. Emile Labo and Ms. Paul Neal for their presentations today. We thank the viewers for joining us and for participating and giving very good questions for our presenters to answer. And we thank again the University of the West Indies, Western Jamaica campus, and the Montego Bay Chamber of Commerce and Industry, along with Dunncox, for putting on this very important and relevant webinar. We remind you again to complete the survey that you will see in your emails, and be assured that the presentations will be forwarded to you if you had registered. And that's why registration is so important. So follow up now and register for the third and final installment, which will be on July 16 at 11 a.m. on the topic, Understanding Data Protection Standards and the Rights and Obligations under the Data Protection Act. Ladies and gentlemen, thank you all for joining us. Have a good rest of the day. God bless.
Thank you very much, Damien, for your very insightful moderating.
Most welcome.
Question. So, it wouldn't have been the same without you. And we'd also like to thank the Montego Bay Chamber of Commerce for partnering with us and UA Western Campus. And so, together, I think it has added to the quality of what was presented. So we thank you very much for the role that you have played.
You're most welcome. It has indeed been a pleasure partnering with Dunncox. Thank you, ladies and gentlemen. Have a good rest of the day.